Love your painting, by the way.
What's that?
Love your dog painting.
Oh, thank you.
Oh, you're still in the office.
I am, yes.
That is his dog, actually. So we're going to let everybody come in. There's still a few people joining in, so I'll wait until we have a lull in people joining and we'll get started. Okay. Looks like we've got everybody in here. There's one more person. It says joining, so she should be in soon. Good evening, everyone. Thank you for joining us. My name is Athena Trenton. If you haven't met me yet, I am the Executive Director of NAMI North Texas. We are really excited to have everybody back together this new year, 2022. And I'm really excited to welcome Chris to our permanent staff. One of the announcements we have for this evening is that Chris Payne, who came on in October as our interim program director, has decided that he loves our NAMI family and he wants to stay. So as of this week, we have, promoted him to our permanent program director, and he will continue to also be the director of our Overwatch peer support program for first responders. It's a new program. I'll let him explain it to you a little bit, but it's a new program. We're starting with law enforcement to provide peer level mental health resources for our first responders. So I am just going to stand in the background, let Chris take over as our program director because he's now fully in charge of all of our general meetings. So Chris, it's all yours.
All right, appreciate it, Athena. Good evening, everyone. For those of you who have not had the chance to meet me, my name is Christopher Payne, or Chris. I am a clinical social worker. I am a former military veteran, Iraq and Afghanistan. I come to NAMI from the nonprofit sector, was a nonprofit clinician for an organization that served veterans and first responders who struggled with suicidal thoughts for about 4 years. I came over here to NAMI to help run the peer support program, and then also stepped in as the program director when that spot became vacant. I am joined by my service dog, Dale, who has decided that he's going to step out of the room, but there's a really interesting picture of him that he gave me for Christmas. So you want to see what he looks like. He's a golden doodle, 3 years old. He helps me with my PTSD and depression, along with some other physical injuries that I incurred during my time in the military. So I have a good background in mental health, not just when it comes to treating mental health, but also when it comes to suffering from mental health or having to deal with mental health issues, because that is something that I've lived with for the majority of my life. So that is where I'm coming from. For those of you who have not met me, would like to get to know me, I'm here in the office Monday through Thursday. Swing on by and say hi. And if there's any issues that you need to talk about or go through when it comes to volunteering, programs, classes, groups, all of that stuff, I'm here for you, okay? So going forward, our big announcement when it comes to 2022 with our groups and classes is that for the first time since COVID, we are actually going to be having in-person meetings again. All right, so we're going to be having in-person classes and some in-person groups. We're not having everything happen all at once. We're going to be doing a trickle effect, see how the world responds to Delta, Omicron, Epsilon, Gamma, whatever other Greek letter is going to eventually be thrown onto one of these COVID variants. And if we need to pull the string, we'll be able to pull the string, but otherwise we're going to let people be responsible and actually go to the meetings themselves and actually get back into the regular routine of taking care of themselves and interacting with others who will help them take care of themselves. So yesterday we were able to post all of our classes and groups online. Registration for the classes will start on Martin Luther King Day. All of our classes are going to be starting in February. We decided to push it a month to the right to see how everything responds to COVID, if anything gets shut down, all of that stuff. So we're about a month behind where we usually are, but we're still moving forward. All right, so right now we're allowing people from the wait list to get on. And then once the MLK Day hits, we will be opening everything up for people to get on. Also that week, the January 17th is when we will start be having groups again. We'll be having both groups in person and virtually. All right, so that's the big announcement for the classes and groups and the other programs. Athena mentioned the OPS, the Overwatch Peer Support Network, that basically this is a regional peer support approach to peer support. So a lot of first responder agencies are turning to peer support as a way to kind of have a stopgap between officers, firefighters, EMTs who are struggling with issues from having to go to divorce court or mental health or counseling or something like that. This is kind of a stopgap of, hey, talk to a peer. Let's see if you all can figure this out together. What we're doing is we're expanding this beyond just within their own agency to include all agencies within the region, so that now instead of maybe having 4 people on a support team that they can talk to, now they've got 54 because of the network that we're creating. So this will be creating more options and expanding those options to the first responders and then eventually the healthcare workers. We're starting right now with law enforcement because we have a lot of individuals within the organization that have helped us get a good foot in the door when it comes to working with law enforcement. Once we have it solidified there, we will be expanding it to fire, EMS, dispatchers, corrections, doctors, nurses, et cetera. And then hopefully we'll be able to take this blueprint to other NAMI affiliates across the country so that they can start to be serving their first responders and frontline healthcare workers as well. So that's the big news about the OPS network and where we're going in that direction. So our speaker tonight is Tresi Weeks. She's going to be talking to us about special needs and estate planning. She's the founder of the Weeks Law Firm in Plano, where she does estate and special needs planning, probates and guardianship. She's very active with the disability rights and the advocacy community. And she's her law practice is specifically surrounding special needs and her desire to help those families who have loved ones with disabilities. So she's the vice president of the Estate Planning Council of North Texas, the immediate past president of the Collin County Bar Association. She's a former chair of the board of directors of Disability Rights of Texas, and she serves on the board of directors for several organizations, including Coventry Reserve and the Dallas Estate Planning Council. She's also the advisory council for My Possibilities in Plano and the Communities Foundation of Texas. She's been recognized as a Texas super lawyer from 2019 to 21, and is also a charter advisor in philanthropy. So Tresi, I'll go ahead and turn it over to you and allow you to present your class to everyone else.
All right, thank you, Chris, so much. Thank you for this opportunity. So what Chris doesn't know is that I have loved ones with serious mental health issues, with bipolar disorder. My closest loved one doesn't give me permission to talk about it, so I'm not going to talk about it, but NAMI is near and dear to my heart, so I love the work that NAMI does. When I was on the board of Disability Rights Texas, Chris, they actually did a lot of work to fight for the right for veterans to have service animals and bring them into certain areas. And so when I was serving Disability Rights Texas, I also chaired their mental health advisory committee for several years, or I was on the board of that and served as the chair. So I love working with families that have loved ones with mental health issues. Not everybody's the same, but I do understand it. So it's, as Chris said, this is what our law firm does, is we help families plan for the future of their child through estate planning, alternatives to guardianship, and things like that. I'm going to share a PowerPoint with you tonight, and I want you to please excuse the pictures and some of the some of the things. This is a multi-purpose This is a multi-purpose PowerPoint. And so I give this also to parents of young kids that have physical disabilities or whatever. So I just ask you, don't be offended by some of these because some of it is more geared toward young people, but we're going to use these to illustrate some points. And so we're going to talk about the top 10 questions about special needs trusts. And so again, this doesn't apply to you guys, but I want to go ahead and go through this scenario because it illustrates some very important points. And so Izzy is a young adult that lives at home, and she is receiving SSI and Medicaid. Now, in 2022, SSI is $841. And so I've got to get that in my mind. I've been used to saying $794. Well, it's $841 now. She gets that. She also gets Medicaid, but she gets some Medicaid waiver programs. And these programs will pay for attendant care. They actually pay her mom to be her attendant, diaper supplies, all kinds of things like that. She's on her father's health insurance plan, and that covers a lot of her medical. She really enjoys her life. She's got an online business. She's got a blog. She's got lots of friends. She's enjoying life. But her parents were so busy giving her a good life now that they forgot to plan for the future. And her parents were not wealthy, but they had a house, cars, bank accounts, IRAs, 401ks, and life insurance. And because they didn't seek the advice of an attorney or do any planning, all of that went to Izzy outright. So what happens to Izzy at that point? Well, she has too many assets, so she loses her SSI Medicaid. But she also lost the Medicaid waiver programs that paid for a lot of different things. And because her father had passed away, she lost her health care. So what that means is the assets that her parents had owned went to her outright, and those assets had to pay for everything for her outright. And as you can imagine, that can be very expensive because she might be able to buy a health insurance policy on the open market, but it's not going to cover a lot of what she needs. Most of her doctors would not be on those plans. And so the assets that her parents left her paid for everything out of pocket. And at some point, the money runs out. So what happens to Izzy's life when that money runs out? Well, she can reapply for SSI and Medicaid and she'll get it. But what does that get her? That gets her $841 a month for food and shelter, and that gets her basic Medicaid. So clearly she can no longer afford to live in her home. And unfortunately for Izzy, she ended up in an institution. And so lost her online business, lost her home, her friends, and it was just a very dismal life for Izzy. And just to let you know, these are not real clients. And because of attorney-client privilege, I'm not going to tell you about real clients. And if you're my client, I'm not telling anybody about you, but these are based on real situations.
So none of these examples are real?
No, they're based on real situations, but these are not real people. These are just stock photos.
Gotcha.
So if you're my client, I'm not going to tell anybody about you. So let's imagine Andrew as another scenario. So Andrew is living in a group home. He is an adult. He's receiving SSI and Medicaid, but the group home that he's in costs more than the SSI of $841. So his parents have been paying the difference. They like this group home because he likes the guys he lives with. It's in the town where he grew up, has activities that he enjoys. Now, the parents knew that if they left assets to Andrew outright, that he would lose his SSI and Medicaid. So they said, why don't we leave everything to our daughter, Susan? Because we know that Susan loves Andrew, and we know that she will use that money to care for him. So the parents pass away. Their assets go to sister Susan. And sure enough, Susan loves Andrew, and she uses that money for his care. She pays that extra money for his group home. But then, unfortunately, Susan died. So if we were in a room together, I would ask you what you think happens to that money when Susan died. Well, you might think it might go to Andrew or it might not, but what happened is that it was part of her estate and it was distributed according to her will. And Susan was married and had 2 teenage kids, and they lived in California. And so her husband didn't have a relationship with Andrew, really didn't know, but all of the parents' money went to Susan's family in California. So everything that the parents had saved up for, they saved their whole life for Andrew, all of that is gone. So what does Andrew's life look like? Well, at that point, he is destitute. All he has to live on is SSI and Medicaid. So he can no longer afford the group home that he wants to be in. So he ends up having to live in a state-funded group home, and it's in a different town. He doesn't like the guys that he lives with. It's really not meeting his needs. And so he lost his childhood town, friends and all of that. So his basic needs were met, but it wasn't the quality of life that he would have wanted. And so I do want to ask that if you have questions, let's wait until the end of those, because what I find is sometimes your questions are answered as we go through. Now, the last scenario is Kyle. So Kyle is also a young adult, and he's got a job. He loves his job, but he is getting SSI and Medicaid. Again, he works at a Kroger. Everybody loves him. People come to that Kroger just to see him. It's in the town where he grew up. He's got a great social system. And so his dad knew not to leave assets directly to Kyle because that would affect his benefits. And so the dad created a special needs trust. And when the dad was creating the trust, he needed to name a trustee, somebody to manage that trust for Kyle when the dad passes away. So the dad had a brother, Bob, so we'll call him Uncle Bob. So Uncle Bob is an accountant. So he said, I'm going to name Bob as the trustee because he's really good with numbers. So the dad dies, his assets go into the trust, and Uncle Bob is the trustee. And so Uncle Bob lives in another state, and he doesn't really have a relationship with Kyle. And so what ended up happening is that he moved Kyle from Texas up to this other state where Uncle Bob lives. And Kyle was not happy there. He was not happy. He didn't like the climate. The people weren't friendly. He just didn't like it at all. But he lost all of his support system here in Texas. So again, his basic needs were met, but it really wasn't the life that his dad would have wanted. So in all of these scenarios, we could have avoided these negative outcomes with proper planning. So first, let's talk about the government benefits that we're talking about. So mostly we're going to talk about tonight is SSI and Medicaid. SSI is supplemental security income. This year, the maximum is $841 a month, and that is to go toward food and shelter. Medicaid is basic medical care. And then there's some Medicaid waiver programs like HCS, CLAS, and some of those. And these can provide therapies, attendant care, residential supplies, different things. And so if you have been in Texas for a while, you know that there's a wait list for these Medicaid waiver programs. And what I'm hearing from my clients is it's taking about 15 years for people's name to come up on that wait list. So if you don't have your son or daughter on those wait lists, you might consider doing that, even if you're not sure if they're going to need those services. So let's talk about the financial eligibility or the eligibility for SSI and Medicaid. Your child has to be sufficiently disabled. And what that means is they have to be unable to engage in any substantial employment due to a physical or mental condition. And they have to have low income and limited resources. Now, Medicaid waiver programs, there's some different requirements for that. So financially, to be eligible for these benefits, your child has to have less than $2,000 in countable resources and less than $2,000 in monthly income. So they have to meet both the resource limit and the income limit. So if your child is working and they need SSI or Medicaid, you're going to want them to make $1,100 or less. If they're not getting SSI, but they're getting Medicaid, then they need to make less than $2,000. So we know that if your child is working, that wages are considered income. But for SSI Medicaid purposes, there's some other things that count as income. Because the SSI check is meant to go toward food and shelter, if somebody else provides food and shelter, that is considered income to your child. where somebody provides something that could be converted to food and shelter, that's considered income. So cash, if somebody gives your child cash, that's considered income. Now, under the deeming principle, when your child is under the age of 18, the income and resources of the parents is deemed to be that of the child. So in many cases, the child won't be eligible for these services until they're 18, because the minute they turn 18, it doesn't matter how much money the parents have or make. They only look at what the child is making. Now, even if the SSI is reduced because somebody's providing food and shelter, in Texas, as long as the individual is receiving at least $1 of SSI, they'll automatically get Medicaid. Now, some of you may say, well, your SSI has been reduced. So under the theory of in-kind support and maintenance, for example, if your child is living with you and you're providing food and shelter, or they're living somewhere else and you're paying for it, under this principle, it will reduce their SSI check by 1/3 of the maximum amount. Now, there are some ways to avoid that 1/3 reduction, and the most common way is to pay rent. So if your child's living with you, you can enter into a written rental agreement with them for $350 or $400 a month, and then they pay that to you, and then your child's SSI should not be reduced by 1/3. If they're living maybe with a roommate, then they could pay their pro rata share, and that would reduce the SSI payment by whatever that pro rata share is. At the end of this presentation, we're going to talk about ABLE accounts, and you might be able to run the rent through ABLE accounts. So there's some cool things we can do there. So we talked about income, let's talk about resources. And so your child has to have less than $2,000 in countable resources. So what they don't count is if your child owns a house, a car, personal belongings, computers, technology, those types of things. A 529 education account does not count against your child either, because they don't have control over it. They don't have a right to demand money from it. What they do count is really everything else. And so if there's a bank account in your child's name or an investment account, UTMA, this is the Uniform Transfer to Minor account. And a lot of people invest in these accounts when the child is young because they are tax advantaged accounts. The problem with the UTMA accounts is that when your child turns 21, they have a right to all of that money. So it will count against your child at the age of 21, even if they don't take the money out. And if your child owns any real estate, things like that, that are not a home. Now, one thing to keep in mind that the benefits are going to be different is, let's say that your child is receiving SSI, and then you start taking Social Security retirement, or the parent, a parent dies, and that parent had contributed into the Social Security system. At that point, your child's benefits are going to change. If your child was disabled prior to the age of 22, then they can be eligible for the disabled adult child benefit. What that means is typically they would be getting 50% of whatever your Social Security check is. So if your Social Security check is $3,000, your Social Security retirement is $3,000, then your child will be getting $1,500. This also applies if you take Social Security disability. So after 2 years, once your child's been on this disabled adult child benefit for 2 years, then they're eligible for Medicare. So they can get Medicaid and Medicare. Now, the problem with this is when we have our clients that have mental health issues, sometimes they're not, or most of the time they're not diagnosed prior to the age of 22. So sometimes it's hard to get this benefit for mental health issues unless you can somehow put together some proof that the condition existed prior to the age of 22. If you can look at school records, mental records, psychology records, anything like that to help with that. There are over 40 different Medicaid programs in Texas, and they have different eligibility requirements. And so when I'm working with a family, if the individual is receiving government benefits, I ask them to show me the benefit statement form so I know what they're getting. So it sounds really generous. It sounds like, wow, Texas has 40 Medicaid programs. they must provide a lot of things. Really, no, it's really hard to get those benefits, as many of you know. Now, I do want to differentiate benefits that are not based on financial need. The first one is Social Security disability. So this is if your child works and then they become disabled. And when they worked, they contributed into the Social Security system. They can get SSDI based on their own work history. Now, there are some kind of other ways to get into it, but that's what that is SSDI. It's not based on financial need. It's based on your child's contribution into the system. And then Medicare is not based on financial need. Now, I've got many clients who their child is on SSDI and Medicare. And so they're saying, do we need to worry about government benefits? But one thing we do need to think about is if they might need Medicaid at some point. Because when we're planning for your child, we're not just planning for now. We might be planning for their whole lifetime. And at some point, they might get old and they might need a nursing home. So Medicare will only pay up to 3 months of nursing home. And if your child needs longer, they'll have to qualify for Medicaid. So in many of my cases, even though the child's benefits are not based on financial need, the parents are still doing a special needs trust so that if that child needs Medicaid, they are eligible for it. So this is a big question we have is your child going to need government benefits? So if your child's not on government benefits now, it's sometimes hard to plan on do we know if they're going to need them or not? What I recommend to parents is think about, is there a possibility that your child will not be self-supporting? If that's a possibility, you can do a special needs trust. Your child does not have to be receiving government benefits in order to do a special needs trust. So what a lot of families do is they do a special needs trust because they want to keep that option open. So if your child's condition deteriorates or something and they need government benefits, then that option's open. If you don't do a special needs trust, then that door is shut. You cannot get to it. So the other thing I do encourage people is that, we don't know what Medicaid, SSI, or government programs are going to look like 2 years from now, much less your child's whole lifetime for decades. So again, I just like to have the flexibility so that we can plan for your child and have the best outcome regardless of what the situation is. So we've mentioned a special needs trust. And so what makes a special needs trust so special? We know that if our child's getting SSI and Medicaid, we know that $841 a month is not enough for them to survive. We know that we have something that we want to leave them when we pass away. We want to supplement whatever they might get, but we don't want them to lose that option of government benefits. So a special needs trust, the assets in the trust are not a countable resource. They do not count against your child for eligibility for SSI and Medicaid. You can have an unlimited amount of money in this trust, and if it's done right, it won't count against them. So first of all, it has to be properly drafted. So you want to make sure that you're going to an attorney that's very experienced in special needs trust, because it is a very complex area of the law. I've had a lot of clients bring to me trusts drafted by an attorney who was not experienced in that area, and it would have been a disaster for their child if the parents had died with those trusts. The trust also has to be correctly distributed in order for it to work. And the result is that the trust supplements those government benefits, but doesn't take the place of them. So if your child needs SSI and Medicaid, they're going to have this basic level of service from those programs, and then what you leave to them will supplement that. Distributions from the trust for the benefit of your child are not considered income to your child for SSI and Medicaid purposes, only if it's done correctly. And we're going to talk in a few minutes about what that looks like. So what is a trust? And so, of course, it's a legal document that we prepare, but in this case, it's also going to be a blueprint for the future care of your child. in this trust, we're going to talk about the people that will be involved, the money, and building a safety net. And that's really what all of this is building a safety net for your child. Now, government benefits are not the only reason that we do special needs trusts. And again, in many of our cases, the child is not on government benefits, but there are other reasons that we do this. And so I draft these trusts with flexibility for change circumstances. So if your child's condition changes or the government benefits changes. So, I will tell you that 10, 15 years ago, if somebody had a pre-existing condition, they could not buy health insurance on the open market. They were excluded because of pre-existing conditions. When that was the law, Medicaid was the only game in town for a lot of people. Now that's a little bit different now with the Affordable Care Act and some of those other programs, but we want that flexibility. So no matter what it looks like decades from now, we want this plan to work. If your child is not receiving government benefits, the trust will operate as a regular trust. So they can use it for food and shelter. They can do different things. But the biggest question that I ask my clients is, if you left assets directly to your child upon your death, can they manage those assets wisely? Would they be able to invest the money wisely? Would they be able to distribute it for their care in a wise manner? If you leave the assets to your child outright, that money is not protected. What we have seen most often is that your child gets taken advantage of because people find out that they've inherited money. And so so-called friends may come and say, hey, I've got a business I want you to invest your money in. And they give it to them and then that money's gone. If you leave it to your child outright and your child gets sued for an accident or files bankruptcy, that money's not protected. It can be gone. Your child gets married and commingles their money and gets divorced. That money could be gone. So leaving assets outright to your child, even if they're not considered disabled, even if they're not on government benefits, we really don't want to leave assets to them outright because it's not protected. Instead, you could leave it to them in a trust, and then you would have a trustee who makes sure the money is invested properly. That trustee will make distributions for your child's care. So if your child says they need a car, then the trustee is going to make sure they get a reasonable car with the trust funds based on how much money is in that trust and how long it needs to last. Now, if your child is not able to advocate on their own behalf at some point, we also will embed some advocacy in the trust as well. So you can see that there are a lot of reasons we create this trust. And that's why my trusts are different than a regular trust, because we're really trying to plan so that we've got this great support for your child. Now, there are two types of special needs trusts. There's a first-party trust and a third-party trust, and the difference is important. A first-party trust is created with the individual's own money. So let's say that your son or daughter inherited $100,000 from Aunt Betty. Well, they could put that into a first-party special needs trust because it's their money. They could put it in a first-party trust and then qualify for government benefits. But the thing about first-party trusts is it has a Medicaid payback provision. So that whenever your child dies, whatever is left in that trust is first going to Medicaid to pay them back for anything they've spent on behalf of your child for your child's entire lifetime. So first-party trust could end up going to the state. Now, a third-party trust is created with somebody's money that's not your child's originally. So if you're creating a special needs trust and you're going to be putting your money into it now or upon your death, that's a third-party trust. The great thing about a third-party trust is it does not have a Medicaid payback provision. So when your child dies, the money in the trust doesn't go to the state. When we draft your trust, we're going to name contingent beneficiaries or remainder beneficiaries, so you can choose who would inherit the trust funds upon your child's death. So if we plan ahead, hopefully we can have a third-party trust instead of a first-party trust. So how does your money get in this trust? This is the most common, is that we would do a will for you. And if you're married, we'd do it for you and your spouse. Your will would leave your child's share to the special needs trust. So the special needs trust is a standalone document. So my husband and I have one daughter who's 25. Her name is Jordan. And so our wills leave everything to our spouse. And then when we both pass away, the assets will go to Jordan's trust. So it goes through our will. So the assets that go through our will would be like our house or bank accounts, things like that. Life insurance. Life insurance is an excellent way to fund your child's future care. So if you think your child is going to have significant financial needs, and if you're still insurable, you might consider talking to your financial advisor or insurance agent to talk about life insurance. But even with the life insurance you have, whether it's through work or if you have private policies, you can name the special needs trust as a beneficiary. This is a great way to do it. So again, for my husband and I, we are each other's primary beneficiary, but our contingent beneficiary is Jordan's trust. So if my husband and I both die, that money is going to go into her trust. IRAs, 401ks, these are a great way to leave assets to a special needs trust. Again, we would do that by beneficiary designation. Also gifts. And so you might have other family members, grandparents, or somebody that might want to give money to your child's trust. They can give money to your trust as well. Child support. I don't know if I've got a, let me check something real quick. Yeah, I do have a slide on child support, so we'll get to that. So this is the funnel. So this is the third party special needs trust we were talking about. It can be an empty bucket and it's not filled until you pass away or you and your spouse. So it just shows the funnel of assets from the will, life insurance, IRAs, 401ks, those types of assets can go into the trust upon your death. So this is typically what we see. Now you can put money in the trust while you're living, but typically we don't see that as much. IRAs and 401ks, and I'm not going to spend a lot of time on that. If your child is getting SSI or SSDI and they've been determined to be disabled, and if you leave an IRA or 401k to them, there's some great tax advantages. Because when you leave IRAs and 401ks to a child who is not disabled, they're subject to a 10-year payout rule. That means that after you pass away, when they inherit that IRA or 401k, they have to cash it out within 10 years. So they can either cash it out immediately, wait until the end of 10 years, or take 10 annual installments. They're going to pay income tax on that. And because you only have 10 years of payout, their income tax hit's going to be pretty big. But when you leave an IRA or a 401k to a beneficiary who is getting SSI or SSDI, they're not subject to that 10-year payout rule. They get a lifetime stretch of that IRA. That means that money can grow tax deferred for your child's lifetime. Now, your child will have required distributions, and those distributions don't start at their retirement age. They would start as soon as they inherit that IRA. But the amount of the distribution is based on your child's life expectancy according to an IRS chart. So that means that the distributions are small at the beginning and become large. So in this particular case, the parents combined had $1 million in IRAs. This is assuming a rate of return of 6%. What this shows is that $1 million grows to about $5 million. So the growth is huge because of that tax-free compounding. On this chart, you can see the light green on the top. Those are the required distributions. So you can see they're small at the beginning and then become large. And so when I'm working with clients who have more than one child, we're deciding what assets to leave to what child. Some of my clients are leaving IRAs and 401ks to their child with who's getting SSI and Medicaid, and then leave other assets to the other kids. And this is powerful if you're in this situation. Now let's talk about child support. So child support can be ordered beyond the age of 18 if a child is considered disabled. So it's similar definition if they're not able to engage in substantial employment. So it can be ordered beyond the age of 18, but it counts against your child as income for SSI and Medicaid purposes. I don't care whose name is on that check, it counts against them. And so the way for example, a woman told me once that, I'm gonna have to change this because now SSI amount has changed. So, well, I guess it's not gonna let me do that, but let's say child support is $900. Well, that's more than SSI of $841 a month. And so she talked to me and she said, my child lost their SSI, but they also lost their Medicaid. Their Medicaid was paying for all their mental health services and a lot of things. And because the child support was more than SSI, they lost Medicaid. They lost all those mental health care. So what we did is their family law attorney applied to court to have that support order modified. We can have that support paid into a first party special needs trust. So when the attorneys bring me in, I do the first party special needs trust, I draft it, and then I provide language to the family law attorney to put in that decree, that support decree, so that it orders the support to be paid into a special needs trust. So that way it doesn't disqualify your child from SSI or Medicaid. So your child can get the child support of $900 a month plus SSI of $841 plus their Medicaid that's providing their mental health services. So this is really, really important. And not a lot of people are aware of this. Not a lot of family law attorneys are aware of it. So let's say that, and let's go back to our third party trust. Let's say that you've passed away, there's money in the trust. What can the trust funds be used for? Well, first of all, what it cannot be used for. The trustee cannot give cash to your child because that's considered income for SSI Medicaid purposes and could disqualify them. We don't get a debit card with this account because that could be considered cash. But typically the trust is not going to be used for things that government benefits pay for. So if Medicaid's paying for something, then the trust is not used to pay for that. What can it be used for? Really, it can be used for anything that you would have used the money for. So it can be used for medical that's not covered, therapies, classes, social, recreation, all their hobbies, activities, entertainment, education, medical. If they're receiving supplements, it can pay for their internet, their Netflix, gaming, all of those kind of things, kind of quality of life, as well as the essentials. So if your trustee cannot distribute cash and cannot use a debit card, and we've got money in this trust, how do they pay for all those things? Well, if it's something where they can write a check or do an electronic payment, they can do that. The trustee can pay third parties directly. But, checks aren't that common anymore. Most people don't do that. So another option is for there to be a credit card that is used for your child. And then the trustee can pay that credit card off each month. So that's an option. But the best option is what we call a TrueLink card. So this is it's kind of like a prepaid card. If you go to truelinkfinancial.com, you can sign up for this card. And what it is it's like a preloaded card. So let's say that your trustee wants your child to have $500 a month for miscellaneous expenses. Then your trustee can load $500 onto that card, and then your child can use that each month. But the great thing about TrueLink is that your trustee can log on and can limit where the card can be used and what it can be used for. So if there's something that your child tends to misuse or something that's not healthy for your child, your trustee can limit that. If your child's getting SSI, and if your trustee does not want the trust to be used for food and shelter, because they don't want that 1/3 reduction. They can limit it so it's not used for food and shelter. So your child could use it to buy a movie ticket, but they couldn't use it to buy the popcorn. So TrueLink, even if you don't have a trust for your child, I love these TrueLink cards because you can put those, those boundaries on it. The other cool thing about TrueLink is I've actually used these for very elderly clients. There was one that was being taken advantage of. People were calling her and she was giving credit card information out over the phone. Another was buying things on QVC that she didn't have the money for. She had a room stacked full of things from QVC that she didn't need, couldn't afford. And so what the family did is they gave her a TrueLink card and they limited it so it could not be used online and it could not be used on the phone. So this protected her from being taken advantage of. But then she can still use it to go to the beauty shop or the grocery store or get gas for the car or whatever. So we also use these like for young adults. These are great options if you're trying to put some safety, kind of a safety net around your child. So we've talked about this trustee. Who is it going to be? Well, let's talk about what your trustee is going to do. So again, imagine you passed away. There's assets in this trust. Your trustee is going to make sure that the funds in the trust are invested properly. Usually they'll work with a financial advisor with that. And then your trustee is going to have the discretion to make distributions for your child's needs. So when your child says, I need something, it's going to be your trustee that says yes or no. Your trustee has to be willing to learn how to make distributions without affecting your child's benefits if your child is on government benefits. They don't have to know today how to do it, but they have to be willing to learn. So with my clients, whenever the parents die and the trustee comes in, I will meet with them for about an hour. And I call that trustee school, where I teach them how to operate the trust without affecting government benefits. Your trustee is going to keep good financial records. They will have an accountant file a tax return on behalf of the trust each year. So you can see that being the trustee is not an honor, it's a lot of work. So obviously you want somebody that you can trust. It can be a family member, it can be a friend. If you're going to name your child's sibling, so one of your other kids is a trustee, keep in mind, how is that going to affect their relationship? So you might not want to do that. For my family, I have a brother that I would trust with anything, but I chose not to name him as a trustee because I didn't want my daughter asking him for money and then him saying no and that affecting their relationship. And so in my mind, the relationship is more important than the money. So there are some options. One of them is corporate trustees. These are professional trust companies. And in North Texas, we're blessed with several that specialize in special needs trusts. So you would have a trust officer that would be making those distribution decisions, and the trust company invests properly. The advantage of using a trust company is that, first of all, they know how to make distributions without affecting government benefits. They are used to dealing with a beneficiary that has mental health issues. No matter what your child's issue is, they are used to it and they're not going to be surprised. But also having a corporate trustee takes the emotionality out of that distribution. So your child cannot manipulate them or whatever, because they don't have that personal relationship. Now, obviously, trust companies have to charge a fee because it's a business. So typically you're looking at about 1.4% of the trust assets per year. And that's for the first $1 million. If you've got more than $1 million, it's a smaller percentage after that. Now, they don't charge that fee until you pass away and there's money in it. And so for my family, we decided to use a corporate trustee just because we wanted to take that emotionality out of it so that everybody could have a good relationship, and then the relationship's not about the money. But when I'm working with a family, we talk about all kinds of options and you get to decide what you want. You might have an individual and a corporate trustee as co-trustees. You're also going to name successor trustees. So if the person that you name cannot serve, then you've got an alternate or 2 or 3. Now, also another option is instead of a corporate trustee, you can use the ARC of Texas. The ARC of Texas has a master pooled trust, and the ARC can serve as the trustee. And this is really good for smaller trusts that may not be worth the fees of a corporate trustee, but you really don't have a family member that you want to be managing the trust. So it's less expensive. It's another good option as well. Now, when I'm preparing a trust for a client, sometimes I might be asking you, let's create what I call a trust advisory committee. And this committee, you would choose 3 to 5 people that would serve on this committee after you pass away. And they're going to be a support team for your child as well as for the trustee. So they can help determine what your child's needs are, help determine how to get those needs met in the community, and they can advocate on behalf of the trustee. Now, the trustee has ultimate authority as to whether to make a distribution or not, but it's just kind of a support team for them. And so some families choose to do this. And if so, we actually name them in the trust document, and we name how successors of this committee will be chosen. Now, if you decide to use a corporate trustee, I highly recommend having this trust advisory committee of friends or family. And then we would give this committee the power to fire and hire that corporate trustee. So we know right now we're naming a good trustee, but what if that bank gets bought out by some big bank and they're not doing a good job for your child? We want somebody to have the authority to go in, and we will change to a better trustee. So this gives you some checks and balances as well. So what happens if you don't have a special needs trust? So what if you leave nothing to your child? And I've seen people who think this is the right thing, as they say, let's don't leave anything to them. But if you don't, and then if they're not able to work, all they have to live on is $841 a month in SSI and then Medicaid. So keep that in mind. You don't want to leave assets to them outright. And if you don't have a will, keep in mind that the state of Texas has one written for you, and I guarantee you it's not what you think. And if things go without a will, they might go to your child outright. And again, it's not protected if it goes to them outright. They might use the money unwisely, and most likely they'll be taken advantage of. You also don't want to leave assets outright to other family members with the hope that they'll take care of your child. And the reason you do that is not that they don't care about your child, but that it's not protected. So in our scenario with Sister Susan, she died and the parents' money ended up with her husband and kids and not with Andrew. But also, what if Susan had gotten sued for a car accident, or if she had filed bankruptcy? All of the parents' money could be gone, or she developed a gambling addiction or whatever. There are thousands of ways that Susan could have lost that money because it's not protected. So we don't want to do that. We want to leave it in a trust, and then it's protected. So we know that you need a trust for your child. What else do you need? Well, you need a will that leaves that child's share to that trust. If your child is under guardianship, then you also want to designate who would be their guardian if both parents pass away. So we do a document called Declaration of Guardian for your child, so that you get to choose who that is. Beneficiary designations, and this is crucial. I would say that 99% of the people that come see me for the first time, their beneficiary designations do not do what they think they're going to do, and they would blow up their estate plan. So beneficiary designations are for life insurance in your retirement accounts, like 401ks, IRAs, those types of assets. Beneficiary designations supersede the will. So no matter what your will says, that doesn't determine where those assets go. So when I work with a family, I actually have them get the beneficiary change form for every life insurance policy and every IRA and 401k, and they get that form to me. And then I write in their child's trust information as a beneficiary, so that we can make sure their child's trust is named properly, because without that, it's not. So it's really important. We also coordinate with other family members. And so I give my clients a letter when they come in and sign their trust. I give them a letter they can give to grandparents or other family members. And those family members can update their will or their trust to leave assets to your child's trust, because you might do all this great planning, but if some other relative passes away, they may not have done that properly. Now, we can't control what others do, but we can provide them with that letter. And if they want to name your child's trust, they can. Now, for you as parents, we're not only planning for if you pass away, we're also planning on what would happen if you were incapacitated for a period of time. So what if you were in the hospital for a period of time and couldn't take care of things? So for you, we're going to do a durable power of attorney that gives somebody authority to pay your bills and things like that. For you, we do a medical power of attorney that would give somebody authority to make medical decisions for you if you're not able to make your own. And then lastly, we do a HIPAA release that gives your medical providers permission to talk to the people that you've listed. Now, this last item, powers of attorney for parents, you also need this for your adult children if they're not under guardianship. So adult children need a financial power of attorney. We call that a durable power of attorney. They need a medical power of attorney and a HIPAA release. So that way, if they're not able to manage things, you've got authority to help them. So in many cases, we can avoid a guardianship if your child has signed powers of attorney. Now, when I'm doing estate planning for a family, if they want me to do powers of attorney for their adult child has to hire me. So they have to email me and say, hey, Ms. Weeks, I want you to do my powers of attorney for me, because they would be my client and they would need to ask me to do that. And then they would tell me who they want as their power of attorney agent and their alternate or two. So as you can see, this is a holistic approach. Just having a special needs trust alone is not enough. We need all of these pieces to work together. And when I'm working with a family, it's very customized based on what the family, what's important to them. Now we're going to switch gears a minute and talk about ABLE accounts. And if we were in a room, I would be asking you how many people know about ABLE accounts, how many people have them. So ABLE accounts allows a person with disabilities to save up to $100,000 without affecting their government benefits. It has to be used for disability related services. But the biggest thing I want you to remember about ABLE accounts is it has a Medicaid payback provision. That means that when your child dies, whatever is left in that ABLE account is first going to Medicaid to pay them back for anything they have spent on behalf of your child from the date the account was open. An ABLE account can be established for somebody that was disabled or blind prior to the age of 26. I know that Congress has talked about increasing that age, but that hasn't happened yet. A lot of people use the state programs, and so you can use the Texas ABLE program, texasable.org, but the Ohio ABLE program has been around longer, and I really like their ABLE program. You don't have to be an Ohio resident. It's all done online. Their website is stableaccount.com. And one of the reasons I like the Ohio account is that you can get a debit card connected with it so that you can track your child can track their spending on it. Now, it can be created either by your child or somebody can open it with them, but your child's considered the owner. But you can only have one ABLE account for your child. If there's more than one, it would disqualify them for SSI and Medicaid purposes. But anybody can contribute to this one account. Now, you're limited. Now, as of January 1st, a few days ago, this amount is now $16,000 per year. So you can only have $16,000 a year of contributions. If your child's on SSI, they can only have $100,000. If they are on Medicaid and not SSI, they can have more, but I wouldn't recommend it because of that Medicaid payback. Now, the money in that account has to be used for disability-related expenses, but the Social Security Administration has told us that they will interpret that very broadly. So this account can be used for education. It can be used for housing, transportation, living expenses, health and wellness, assistive technology, personal support, legal fees, all kinds of things. Again, it's a tax advantaged account. It's like a 529 education account. In fact, the ABLE Act is Section 529A of the IRS code. Now, distributions from the trust are not considered income for SSI purposes. But here's the catch, is that if your child's receiving SSI, the Social Security Administration may want to see records each year of that ABLE account and how that was spent. So what I recommend that people do is, again, if you've got that debit card, you can keep some track, but I would recommend you keep receipts. And for me, the easiest way to do that is to get a scanning app on the phone. Your child can get a scanning app, and then they can scan a receipt and then save that to a Dropbox folder or somewhere so that you've got a PDF copy of those. So if the Social Security Administration ever asks for those records, you can provide it. Again, that Medicaid payback is the biggest thing. I had somebody come to me and they said, and because 529 accounts are tax advantaged accounts, if it earns an income on the investments, there's no tax if it's used properly. And so financial advisors were telling them, hey, start socking away all this money in an ABLE account, but nobody told them about that Medicaid payback provision. And I said, are you willing to donate all of that money to the state if your child dies? And they said no. So keep that in mind when you're setting these up. I would not use it as a savings tool for your money as the parent because of that Medicaid payback. Now, if there is a 529 education account for your child, and then your child's not going to need that for education, you can roll that over into an ABLE account. So not everybody needs an ABLE account. So when do we use them? Well, let's say that your child is working and they can only have $2,000. What if they're getting up to that limit and they want to save some of their money? Well, they can open up an ABLE account and move some money over in order to save it and have more than $2,000. We've also used it if your child inherits a small amount, like let's say that Aunt Betty leaves your child $10,000, they can just pop that over into an ABLE account and then it won't count against your child, and then they can use it as they need. But the other cool thing, we talked about rolling over a 529 education account, but the other cool thing is paying rent. So let's say that your child is living in an apartment and you are paying $1,000 in rent for them. If you're paying for rent, you're providing food and shelter, and that would reduce your child's SSI by 1/3. But if you put that $1,000 in the ABLE account and then immediately pay rent from that, it does not reduce your child's SSI. So I call it legal money laundering. This is really cool. So it doesn't work if your child's living with you, but if they're living somewhere else and you're paying for it, this is an option. Now, if you're paying for rent or housing through an ABLE account, there are some special rules. You have to make sure you're doing it right. So ABLE accounts are a new tool. They're low cost. In most cases, they don't replace a special needs trust, but in some cases, they're very helpful. So we're going to switch back to our special needs trust. The question we often get is, when do you need to create a special needs trust? And for some reason, people think it's related to when your child turns 18 and need to talk about guardianship. But really, you need to create this trust before you die or become disabled. We obviously don't know when that is. So what I have found is that the sooner you can get it done, the better. And then it gives you peace of mind to know that you've got a plan in place. And that's one thing I love about my practice, is that when we've got a great plan in place, our clients sign all their documents, I can just see the tension leaving their shoulder because they've got a good plan in place. When I'm working with a family, most of my clients come see me every 3 years, and we can talk and touch base, see if we need to make any changes. But I found that also takes pressure off of you to know that you only have to plan for the next 3 years. What if you were to pass away in the next 3 years? Who are you going to name as your trustees, and what are you going to do? And then you can reevaluate it. So again, that takes some pressure off of you to know that all we have to do is create a plan based on your child's condition today, based on your financial situation and your family situation today. So what is the result of wise planning? What if we do this right? You're going to have a financial plan to pay for your child's care if they're not self-supporting. You're going to have a support team in place for them. You might have instructions for their care, but they're going to retain that option to be eligible for government benefits if they should need them. But the result is just a well-being, a better life. So let's go back to our scenarios. And for those of you who join later, I know these scenarios don't fit in the mental health community, but this is an all-purpose PowerPoint, so I'm still going to use those. But if you'll recall with Izzy, is that she was receiving SSI of $841 a month. She was getting Medicaid, but also Medicaid waiver programs that were paying for her mom to stay home, paying for all kinds of things. The parents didn't have a plan. Their assets went to her outright, had to pay for everything out of pocket. And when the money ran out, she ended up in an institution. What if her parents had a special needs trust and their will left assets to that trust, and they changed their beneficiaries of their life insurance, IRAs, and 401ks to go into that trust? Well, then when the parents passed away, all of their assets would have gone into that trust. She still would have received SSI and Medicaid that would have given her a good basic level of care. And then the parents' money would have supplemented that. So with the SSI, Medicaid, and waiver programs, plus what her money left, what her parents left, she was able to have a really good quality of life. She could stay in her home if she wanted to, or she could live in a condo or somewhere else because she's got money for choice. She would be able to keep her friends, her blog, and she would not have ended up in an institution.
Just for Izzy.
And then let's imagine Andrew. So remember, his parents saved their whole life to pay for his care. And then they left it to Sister Susan, and she died, and it went to her family. And Andrew could no longer afford that group home. And so he ended up in a different town with people he didn't like, and he lost his friends and the enjoyment that he had. What if the parents instead had created a special needs trust for Andrew and named Susan as the trustee? And when the parents passed away, their assets went into that trust. Well, then Susan could have used that money for Andrew's care. But then when Susan died, the money would not have gone to her husband and kids. It would have stayed in the trust for Andrew. And the parents would have named a successor trustee who would have stepped in and used that money for Andrew's care. So that means Andrew could stay in that more expensive group home that he was in, stay in the town that he loved with all his friends, and still had a great quality of life. And then lastly, if you'll remember, Kyle, his dad had a special needs trust, but Uncle Bob in another state was the trustee. And he ended up moving Kyle up there, and Kyle was miserable. Well, what if in the special needs trust, the dad had named a trust advisory committee? So what if we'd had a group of 3 to 5 people here in Texas that knew Kyle? Then they could have advocated on Kyle's behalf and said, Uncle Bob, Kyle loves his job here. He loves living in his hometown. We don't want him to move there. Kyle doesn't want to move to that state. And then that would have worked out great because Kyle could have stayed here and still had the great quality of life that he wanted. So those are just some scenarios. This is our contact information. If you do not have a special needs trust attorney and you want to work with our firm, feel free to give us a call. I'll tell you what our process is when you call, our assistant will take your basic information, and then we're going to send you a worksheet to complete. And this is an electronic worksheet. You'll fill it out online. You can save it, come back to it. But it's going to ask you questions about you, your family, and your financial situation. It's entirely confidential. It's just so that I can advise you. It's information I need in order to help you with your plan. And then once you get that back to us, then we would schedule an initial consultation with me. Our initial consultation is $500 per hour. Typically, that's about an hour, unless you wanted longer than that. At that consultation, we'll talk about what your goals are, talk about your family, finances, and typically I'll give you some options. I do this work usually on a flat fee. So by the end of the appointment, I typically will make recommendations, and I might give you like 2 or 3 options and tell you the pros and cons of each package. And I'll tell you what the fee is for those. So you're going to know exactly what those are. You can choose which package you want, or if you want to proceed. If you don't want to proceed, then all you pay is that consult fee. But if you want to proceed, then you would pay half of the package up front, the other half about a month later. And then we would schedule your signing appointment, which again is typically about a month later. And then at that signing appointment, we're going to provide your witnesses, your notary, get everything signed, and then we're going to scan your signed documents. We'll save each one as a PDF file and put that on a flash drive for you. So you'll leave our office with a binder with the original documents and then the flash drive. Again, we ask our clients to get the beneficiary change form for life insurance, IRAs, so that we can make sure your child's trust is taken care of. And so the fees for this package is vary depending on what you want. But we would give you a flat fee, so there's no surprises there. So feel free to give us a call if we can help you guys. I'm going to turn off the PowerPoint. And Chris, do you want to have some time for questions, or do you want to wrap up? What do you want to do?
No, we do have time for questions.
Okay.
It is 8:10 right now, so let's do about 10 or 15 minutes for questions, unless nobody has any questions. And then after that, we'll go ahead and wrap up. So if anyone does have any questions, just go ahead and speak up, or raise your hand, or throw it in the chat, and we will get the question asked. Okay.
I have a question. This is Margie. What if your child is fairly independent? What is the most control they can have over the money in a trust, rather
Margie,
than feeling really dependent on others?
Yeah, Margie, that's a good question. If it's going to qualify as a special needs trust, your child cannot have any control over the money. So somebody else has to be the trustee, and your child cannot ever be the trustee. Now, if your child does not need government benefits and it doesn't need to be a special needs trust, it can be a regular trust, then your child can be the trustee of their own trust or a co-trustee with someone else. Now, with our children that don't need a special needs trust, then I'm not sure what's happening here. Somebody is, Chris, you may want to stop the share screen feature.
That is what I'm doing.
Okay, because somebody is sharing screen and that's not my screen. There we go.
All right.
So
Is the money in a regular trust still not counted as income if they are receiving SSI and things like that?
no, if it's in a regular trust, Margie, it counts against them for SSI. So if they're going to need SSI or Medicaid, unfortunately, with the trust, they cannot have any control over it ever. Now, the trustee typically is going to work with them, but if you give your child any control, it counts against them. Joanne?
Okay. Everything you have discussed for the special needs trust relies on the facts that the person has basically SSI or disability and then Medicaid. So is it true then, to my thinking, that a person who is on Medicare would not be appropriately directed toward a SNT? Or
So in many situations, they won't, because a regular trust doesn't disqualify from Medicare or SSDI. But the question the clients want to ask is, will they ever need Medicaid in the future? Would they need Medicaid for long-term nursing care or something? So sometimes people want to leave that option open so that if they ever need to qualify for Medicaid long-term care, they can. But you're correct in that they don't need a special needs trust if they're getting SSDI and Medicare, and they will never need Medicaid. But that is my question is, are you sure they're never going to need it? And that's something for you to think about.
would a living trust be the more appropriate thing for that?
So Joanne, a living trust is a trust that you create for yourself. And then upon your death, it can then create a trust for your child. So yes, that would be an option. That trust for your child, if it's not a special needs trust, can either be in your will or it can be in your living trust.
Okay, thank you.
Yes, and it looks like Jeff has a question.
Hey, hi, this is Linda, and I'm with my husband, Jeff.
Okay.
I have a question. So you did speak to it, but I think I missed it. So my son has special needs, he has mental illness, and we were thinking of having his sister as a trust person. Originally, we thought we would just give her the money and she would take care of it, but now you put some doubts in my mind as to things that can happen. So let's just say she's married and she is the trustee and she gets killed in an accident. Should we have set up somebody else as the trust as an alternate, or what can we do at that point? Say we're gone, and what if we didn't do that? What if we didn't set up someone alternate?
So when you draft the trust, I'm going to ask you to name alternates.
Okay.
But if there is no alternate, my trust document will state how a successor is named. So there will be a way to name a successor trustee.
Yeah, because I mean, you might think like, well, the husband would be fine, but sometimes, marriages end and different things. And then I had one other question. So I do get Social Security, and when I applied for it a couple of years ago, they said, oh, well, your son would qualify for the DAC, disabled adult child, because he was less than 22 when he became disabled. But I mean, I get close to $2,000 a month. He gets $64. Like you had mentioned, they usually get half. Like, I mean, he gets SSDI. I mean, I'm just wondering, his amount was such a small amount, but I thought, well, whatever, we'll take it, but.
Yeah, you might want to go back to Social Security and see why that is. They might be reducing because of food and shelter, or I would definitely contact them and try to get more. It should be half of what you're getting.
Yeah, because I think at the time, well, currently he's in a hospital, but at the time I think he was homeless, so he had no supposed needs for shelter because he lived out of his car, so there was no money being paid out anywhere. So
yeah, that's not a valid argument.
Okay,
He should get it regardless of his housing situation.
Okay, all right, thank you.
All right. Well, it has been a pleasure. I hope that this gives you some peace of mind. And that's really my goal here, is to let you know that this is doable, that it's not as intimidating as you might think. So I hope that helped you. I think, Ron, you've got a question?
Yeah, sorry about
Yes.
jumping in late. I was waiting for the others to finish. On the completion of all the trust, especially getting down to the trustees, other, trustee advisory, once the fees are paid to the law firm, do the trust accounts have an ongoing fee built into them depending on what trust accounts? In other words, so if I said ABC Bank is going to be the trustee, the advisory council is going to be that, then they, get bought out. Are there going to be fees after I pay your company for setting up these trusts?
No, there's not an ongoing fee. Typically, it's just drafting the trust. When you pass away, if you have a corporate trustee, they charge a fee every year to manage the assets for you. But other than that, there's not. Your trust can provide that your trust advisory committee can be compensated or reimbursed. If you have an individual as a trustee, the trust can provide that they would be compensated or reimbursed. But as far as, legal fees for us, no, it's typically a one-time thing. Down the road, you might want to do an amendment. If we're doing amendments, we charge typically on an hourly basis. So if it's a 1 hour job, it's going to be something small. So typically any changes are going to be much smaller compared to the initial investment.
I get that. I had a good friend of mine that became the trustee of his friend that died, and it was the worst experience he's ever been through in his life. Because the family members were all over him about getting money out of that trust, getting to him. So it's, yeah, I just, that's don't want to go there with that, but
Yeah. Yeah, I mean, not to scare you, but when my mom died, my brother, I was the trustee of his trust, and he had significant issues, and I wouldn't give him money. I gave it to his minor daughter instead, and he tried to sue me. So no lawyer would take his case, but you have to have somebody that's willing to put up with that if that's going to be the situation.
when you said the first hour, I missed that. You said it was an hour consultation.
Yes.
Did you say $500?
Yes, that's correct. And then if you needed, 2 hours, then it would be 1,000, but typically we can cover it in an hour unless you've got more questions.
All right, thank you.
If you have prior documents that you want me to review, I can also review those on an hourly basis as well.
All right, we still got time for maybe 1 or 2 more questions if anyone has anything they want to ask.
I just want to say thanks for presenting such a wonderful program. It was very understandable. And the PowerPoint, of course, always helps. It really does. But also the straightforward description, I thought was excellent. So thank you, Ms. Weeks. And I was glad I tuned in.
I agree. This was very informative.
Thank you. Well, you're most welcome. It's my pleasure.
All right, well, Trustee, I appreciate you being able to come on and join us this evening.
All right. Thank you, guys. Bye-bye.
Thank you very much.
We've
All right.
been calling you.
All right, folks, so we're going to go ahead and wrap it up for this evening. I want to thank everybody for logging in and joining us. Our next monthly meeting will be in February, I believe February 3rd. I'll need to double check my calendar, but I believe it's February 3rd. Until then, be safe and have a good rest of your evening. All right,
Thank you.
I'll stick around to answer any questions anyone has. Athena will stick around. Otherwise, y'all take care.
Thanks.
Did you get some good information, Claudia?
This is a wide open segment, let me tell you. I thought I have everything figured out until I came tonight. Big awakening. Big awakening. Actually, probably next week I will call her. Definitely.
Yeah,